In this installment of Washington Legal Foundation's Legally Brief, we are joined by Wilson Sonsini, Goodrich, and Rosati attorney Jerry Stigmeyer, and our topic is the use of class action lawsuits to redress supposed violations of online consumers' privacy interests. Jerry, such class actions lawsuits have been with us for some time, but with all the attention in the press and from elected officials and regulators on online privacy over the last year or so, have you seen a rise in such suits being filed?
You know, Glenn, that's a great question. We are seeing a dramatic increase in filings of consumer class actions alleging invasions of privacy. The numbers, don't lie. Some could say it's even the latest cottage industry in the field, and it's really something that troubles many of us in the business field and supporting business clients.
Which federal and state laws have been the most frequent source of citation for privacy-related class action suits like these?
So the most common federal statutes that we seem to see included in complaints that are filed are those that enable a party to recover attorney's fees or otherwise provide for statutory damages. As a generality, the Electronic Communications Privacy Act is one that we continue to see claims, as well as the Computer Fraud and Abuse Act and state laws that are similar, where plaintiffs allege unauthorized access or access in excess of authorization to computers. The reality is that people continue to use the internet in new and exciting ways. There's a tremendous amount of innovation, and yet there are many federal statutes out there and state statutes that, if applied or construed in a certain way, create colorable claims. So there's an enormous amount of litigation, and the reality is that we don't have a comprehensive privacy framework in the United States. So there are more than 200 federal laws that touch upon privacy in one way or another, and we're seeing a lot of litigation testing those laws and their application to new technologies.
Now, the threshold issue for these kinds of suits is whether the plaintiffs have standing to sue, which requires some type of injury. How successful have plaintiffs been in getting over this hurdle?
So about 10 years ago, we really thought we were going to see a tidal wave in privacy litigation, and it's taken some time for that tidal wave to mature. And part of that maturity, or lack of maturity, candidly, is that for many years, defense attorneys and their clients have prevailed on the notion that there aren't any damages in these kinds of cases. And in the last couple of years, in particular in a case that we worked on, Bell versus Axiom, federal courts have recognized that often there aren't injuries or injuries of the type or nature sufficient to confer standing. But we're continuing to see innovative theories and courts willing to test and reevaluate that, particularly in the Ninth Circuit.
What kind of lessons can businesses derive from some of the rulings that have come out of these kinds of privacy-related class action cases?
Well, an unfortunate lesson that businesses can take away from consumer class actions related to privacy issues is that things that they were doing or innocently believed would be acceptable might be troubling to small groups of the population, and unfortunately the financial incentives are such that they'll be faced with significant and large costs of defending cases that are completely surprising for many business executives. So I think sort of a second lesson to take away is the reality is that privacy issues, and in particular consumer perceptions of privacy and legislative perceptions of privacy, have taken on a new importance, a new significance, which have elevated privacy and information governance to issues that are routinely discussed in the boardroom. In many respects, privacy and information governance represents the new environmental, as it were. Right. So if we look back at a history of environmental regulation and how that sparked and we saw significant litigation, I think there's some important parallels that one can draw to the litigation we're seeing over privacy and information governance, and even in some respects paralleling litigation that we've seen with respect to securities litigation, which is to say that there can be, although there isn't always, propensity to file the case first and figure out whether there is a case later. And that's very troubling, especially because many businesses take these issues, very seriously. That isn't to say that some things aren't that there aren't some problems and there isn't room for improvement. But the dynamic between discovery cost and other types of incentives are such that businesses can expect that at least in the foreseeable future, they're going to continue to be sued, and they should take those risks seriously. And what that means for those of us in the field is often companies will act more conservatively than they might otherwise act. They might innovate less than they might otherwise innovate, out of fear or concern for this type of litigation. So it's really very troubling.
Jerry Stegmeyer, who is with the Wilson Sonsini firm here in its Washington, D.C. office, thank you for joining us today.
Thank you.